as well as there was a provision for adjudicatory authorities. If the rights of the consumers are violated, then they have not to go to ordinary civil court, but they can directly go to adjudicatory authorities provided under the Consumer Protection Act. So this is the very unique feature of the consumer protection law. But before going through all these things, I would like to quote a statement of that he has rightly said, consumers are to economics, are to politics. तो जैसे ही राजनीति में मतदाताओं का महत्व है, उसी प्रकार से अर्थशास्त्र के क्षेत्र में कंज्यूमर्स का बहुत ही इम्पोर्टेंस है, और वो न केवल पर्सनल गेन के लिए उनके लिए लाभदायक है, बल्कि ये नेशनल इकोनॉमी को भी अफेक्ट करता है। अगर कंज्यूमर को अच्छा प्रोटेक्शन मिलेगा, कंज्यूमर्स अगर हैप्पी होंगे, तो नेशनल इकोनॉमी भी फ्लोरिश करेगी। कंज्यूमर्स आर रिगार्डेड एज द किंग ऑफ द मार्केट, उनको मार्केट का बादशाह माना जाता है। कंटेम्परेरी एरा इज मार्क्ड एज द एरा ऑफ कंज्यूमर्स। कंज्यूमर इज ए रिलेटिव टर्म एंड ईच ऑफ अस इज ए कंज्यूमर एट सम पॉइंट ऑफ टाइम। मतलब हम सभी लोग कंज्यूमर हैं। In the environment of limited choice, inadequate supply, incomplete information, and unlimited demand, there is more possibility that consumers may be cheated in the hands of businessmen and traders who are in superior position as compared to consumers. मतलब कंज्यूमर्स की जो पोजीशन है, दे आर वीकर पार्टी इन कंपैरिजन टू बिजनेसमैन एंड ट्रेडर्स एंड सप्लायर्स ऑफ द गुड्स. सो इन दिस बैकग्राउंड it is very important and relevant that we should talk about consumerism. Consumerism is all about protection of interest of consumers. It should not be considered as a war against the businessman. कंज्यूमरिज्म का ये मतलब नहीं है कि हमें बिजनेस के खिलाफ लड़ाई लड़नी है, बल्कि हम ये कह सकते हैं कि इट इज ए कलेक्टिव कॉन्शियसनेस टू एनहांस द कंज्यूमर सेटिस्फैक्शन एंड सोशल वेलफेयर ऑफ द सोसाइटी. कंज्यूमरिज्म इज स्टिल इन द इन्फेंसी इन आवर कंट्री ड्यू टू सेलर्स मार्केट एंड गवर्नमेंट मोनोपोली इन मोस्ट ऑफ द सर्विसेज. हमारे देश में सेलर्स, जैसे मैंने आपको बताया कि दे आर इन स्ट्रांगर पोजीशन, दे आर स्ट्रांगर पार्टी, और अधिकांश सर्विसेज जो है वो गवर्नमेंट के क्षेत्राधिकार में है. इसलिए वहां पर बड़ी संभावना रहती है कि कंज्यूमर को न्याय मिल नहीं पाएगा. But the effect of the consumerism is emergence of consumers' rights. कंज्यूमरिज्म का जो मूवमेंट है, जो सोशल मूवमेंट है, इसका सबसे अच्छा जो परिणाम है ये है इमरजेंस ऑफ कंज्यूमर्स राइट्स. और कंज्यूमर्स को जब राइट प्राप्त हो जाएंगे तो वे अपने राइट को प्राप्त करने के लिए, उसका वायलेशन होने पर रेमेडी के लिए एफर्ट कर सकते हैं. In the meantime, the consumer markets witnessed drastic transformation with the emergence of global supply chain, rise in international trade, rapid development of e-commerce, leading to new delivery system. मतलब अभी जो हमारा मार्केट है, जो कंज्यूमर मार्केट है, उसमें ही ड्रास्टिक चेंजेज आ गए हैं और वह इंटरनेशनलाइज हो चुका है. In this background, there are two strong enactments which are very much helpful to protect the rest of the consumer and promote their interest. दो ऐसे कानून बने हैं इस बीच जो कि कंज्यूमर्स के राइट प्रोटेक्ट करते हैं और उनके हितों को बढ़ावा देते हैं. इसमें एक कानून है कंपटीशन एक्ट 2002 और दूसरा लॉ है कंज्यूमर प्रोटेक्शन एक्ट 2019. दोनों लॉ कंज्यूमर के प्रोटेक्शन को टारगेट करते हैं, लेकिन दोनों का तरीका अलग अलग है. They protect the interest of the consumers differently. Consumer Protection Act does so explicitly, while Competition Act does so by necessary implication. The Consumer Protection Act addresses consumer disputes against traders directly, while Competition Act addresses consumer welfare indirectly by regulating the markets and ensuring more choices to the consumers. As I told you that the new Consumer Protection Act 2019 came into force from July 2020 by replacing, reforming, and repealing the earlier Act of Consumer Protection Act 1986. This 1986 can be said to be a boon for Indian consumers. This act was basically intended to provide for better protection and promotion of consumers' rights. This act was amended from time to time to make it in accordance with the changes in the market. However, the practical implementation was far from fulfilling its desired objective. दो महत्वपूर्ण परिवर्तन हुए हैं, या इस इनेक्टमेंट के द्वारा दो महत्वपूर्ण परिवर्तन लाए गए हैं. पहला जो परिवर्तन है कि हमारा जो 1986 का कंज्यूमर प्रोटेक्शन लॉ था, दैट वाज बेस्ड ऑन द डॉक्ट्रिन ऑफ कैविएट एम्प्टर, क्रेता सावधान के सिद्धांत पर आधारित था. बट दिस कंज्यूमर प्रोटेक्शन एक्ट 2019 is based on the doctrine of इस अधिनियम के द्वारा यह स्पष्ट हो जाता है कि अब विक्रेता का सिद्धांत आ गया है, सेलर बीवेयर इन प्लेस ऑफ बायर बीवेयर. नाउ इट हैज बीन सेलर बीवेयर. दूसरा परिवर्तन यह है कि कंज्यूमर प्रोटेक्शन एक्ट 1986 was not a class legislation, but if we study section 10 clause 1 of this act, now the Consumer Protection Act 2019 is protecting the interest of the consumers as the class legislation. So these are two additions in the Consumer Protection Act 2019 which were not in earlier law. For example, in the new act, there is provision for product liability. There is separate regulatory authority called as central authority. just like the Competition Commission of India, we find establishment of consumer mediation cells. There is punishment for misleading advertisements. The pecuniary jurisdiction of the consumers forum have been increased. The definition of goods and consumers has been modified, and appeal-related provisions have been made more stringent.
I think the link. I think the connection has been broken of Professor. I'm trying to call him. Please wait for a second. Till Professor Upadhyay joins us, it was a really very important session which he was talking about. He was talking about the new provisions which the new Act, the Consumer Protection Act 2019 has, in the new Consumer Protection Act 2019, what are the new provisions which was not earlier than the Consumer Protection Act 1986. So he was talking about those. I would also like to give you a brief about what are the new provisions. The highlights of this act is, the 2019 act is that it is better than the earlier act. As he already told, that the act, in the earlier act, the act was based on the doctrine of caveat emptor, where यहाँ हम लोगों को दबाया had to be aware. If you're buying something, आपको ये जानना जरूरी है कि आप जो खरीद रहे हैं, आप खुद responsible हैं उसके लिए. So Professor Upadhyay has joined. So I was telling Professor Upadhyay that as the earlier act was more based on the doctrine of caveat emptor, which you have already told, and the new act is based on the seller be aware. So यहाँ हमने seller के ऊपर ये जिम्मेदारी है कि उनको अवेयर होना चाहिए कि वो क्या बेच रहे हैं, और ये उनकी रिस्पॉन्सिबिलिटी है कि वो हमें गलत चीजें ना बेचें. तो ये यहाँ पर ये चेंज बहुत ही महत्वपूर्ण है, बिकॉज पहले एक्ट में था कि हमें खुद सोच समझ कर खरीदना था. अब यहाँ पर सेलर के ऊपर ये रिस्पॉन्सिबिलिटी आती है कि आप एडवर्टीजमेंट्स के सहारे कुछ भी हमें नहीं बेच सकते, जो आप चाहे हमें नहीं बेच सकते, बिकॉज नाउ दे हैव टू बी मोर अवेयर व्हाट दे आर सेलिंग. और मिसलीडिंग एडवर्टीजमेंट्स वगैरह के सहारे वो हमें एल्यूर नहीं कर सकते हैं. तो जहां एज वी नो दैट कंज्यूमर इज द किंग, और कंज्यूमर बहुत ही इंपॉर्टेंट है कंज्यूमर का होना. अगर कंज्यूमर नहीं है तो फिर डेफिनेटली ये जो सारा मार्केट है वो बेकार है. तो प्लीज कंटिन्यू सर.
Okay, ma'am. Sorry, there was poor internet connection. First of all, we will take up one by one every point. The first point is about product liability. The first time in this Consumer Protection Act, there is provision for the product liability. Product liability means अगर कोई product डिफेक्टिव है या उसके डिजाइन में अगर कोई कमी है तो उसके लिए अगर लाइबिलिटी की जो बात आती थी तो जो हमारा पुराना एक्ट था 1986 का उसमें भी प्रावधान था, बट देयर वाज नॉट ए प्रोविजन फॉर द प्रोडक्ट लाइबिलिटी ऑफ द मैन्युफैक्चरर और रिटेलर. जो सेलर होते थे दे मे बी हेल्ड लाइबल अप टू सर्टेन एक्सटेंट, बट नाउ एंड एज फार एज द लाइबिलिटी ऑफ द मैन्युफैक्चरर और रिटेलर इज कंसर्न्ड, हमें मतलब ऑर्डिनरी सिविल कोड का सहारा लेना पड़ता था एंड दैट वाज वेरी टाइम टेकिंग एंड वेरी एक्सपेंसिव आल्सो. So this is a new provision, and this provision provides about the liability of the manufacturers and the retailers as well as the sellers of the goods. And the consumer who suffers the loss due to any defective good or any poor services of the service provider, he may be compensated from that retailer or manufacturer or the service provider. Actually, this act explicitly provides for the breakup of the liability of the product manufacturer, retailer, and product seller, and all of them may be held jointly or severally liable. मतलब उनका संयुक्त या पृथक दायित्व होगा और उन सभी को जिम्मेदार ठहराया जाएगा. तो ये बहुत बड़ा एक यूनिक फीचर है इस नए लेजिस्लेशन का, जो कि कंज्यूमर के लिए बड़ा हेल्पफुल होगा. और सेकेंड पॉइंट है मैम, इस्टेब्लिशमेंट ऑफ सेपरेट रेगुलेटरी अथॉरिटी, सेंट्रल कंज्यूमर प्रोटेक्शन अथॉरिटी. इट इज आल्सो नोन एज द सेंट्रल अथॉरिटी. और इस अथॉरिटी की संरचना है कि इसके राइट्स का अगर कोई वायलेशन होता है या कोई अनफेयर ट्रेड प्रैक्टिसेस की जाती हैं या कोई फॉल्स या मिसलीडिंग एडवर्टाइजमेंट होता है तो उसको रोकने के लिए डायरेक्ट एम्पावर्ड है. इसके अतिरिक्त ये अथॉरिटी कंज्यूमर्स के राइट को प्रमोट करेगा, प्रोटेक्ट करेगा और उसको इन्फोर्स करेगा एक क्लास के रूप में. और सबसे बड़ी विशेषता है इस अथॉरिटी की कि इसके साथ एक इन्वेस्टिगेटिव विंग भी है जो कि इन्वेस्टिगेशन का काम कर सकता है. जिस प्रकार से हमारे कंपटीशन लॉ में कंपटीशन कमीशन ऑफ इंडिया में डायरेक्टर जनरल होता है इन्वेस्टिगेशन करने के लिए, सिमिलरली देयर इज प्रोविजन अंडर द कंज्यूमर प्रोटेक्शन टू गेट द मैटर्स. मतलब ही कैन द अथॉरिटी कैन ऑर्डर फॉर द इन्वेस्टिगेशन ऑफ द मैटर सुओ मोटो और ऑन द बेसिस ऑफ द कंप्लेंट ऑफ द कंज्यूमर. तो ये बहुत बड़ा एक फीचर है कि इसमें इन्वेस्टिगेशन करने का भी पावर दे दिया गया है और जो भी इन्वेस्टिगेशन का रिपोर्ट होगा accordingly they can file the complaint or they can prosecute the persons or they can order for the recall of the unsafe goods and services or they can pass order for the discontinuance of the unfair trade practices or they can order for the reimbursement of the price. They can impose the penalties for the misleading advertisements. तो ये जो अथॉरिटी की का इस्टेब्लिशमेंट किया गया है ये बहुत ही लॉडेबल स्टेप है और यह कंज्यूमर के प्रोटेक्शन को बहुत ही एक्टिवली प्रोटेक्ट है कंज्यूमर्स को. एंड दिस द रेमेडी अगेंस्ट दिस order of the central authority is only that the person can go in appeal before the National Consumer Commission. मतलब अगर इस अथॉरिटी का कोई ऑर्डर आया है तो उस ऑर्डर के खिलाफ कंसर्न्ड पार्टी को केवल एक ही रेमेडी है कि वो नेशनल कमीशन में अपील कर सकता है इस ऑर्डर के अगेंस्ट में। तो बहुत ज्यादा टाइम कंज्यूमिंग नहीं होगा और इजी रेमेडी दी जा सकती है इसके माध्यम से। और एक महत्वपूर्ण जो फीचर है इस न्यू लेजिस्लेशन का वो है टू प्रोवाइड फॉर द अल्टरनेट डिस्प्यूट रिजोल्यूशन मैकेनिज्म इन द कंज्यूमर प्रोटेक्शन लॉ। जितने भी हमारे 3 टायर सिस्टम है कंज्यूमर कमीशंस का, डिस्ट्रिक्ट कमीशन, स्टेट कमीशन एंड नेशनल लेवल कमीशन, एट ऑल द लेवल्स उन कमीशन से जुड़े हुए मीडिएशन सेल की स्थापना की जाएगी जिसमें देयर विल बी लिस्ट ऑफ द मीडिएटर्स एंड इफ द कमीशन थिंक्स दैट द मैटर शुड बी रिजॉल्व थ्रू द मीडिएशन तो वो मामले को रेफर करेंगे और पार्टी अगर एग्री करती हैं तो मीडिएटर्स जो है वो मीडिएशन करने के बाद मीडिएशन रिपोर्ट तैयार करेंगे और उस रिपोर्ट को कंसर्न्ड कमीशन के पास भेज दिया जाएगा और जो कंसर्न्ड कमीशन होगा दैट शैल पास सुटेबल ऑर्डर एंड डिस्पोज द मैटर अकॉर्डिंगली। तो इस तरीके से मैडम एक इससे जो हमारे कमीशंस हैं उनका भी वर्कलोड कम हो जाएगा और समय की बचत होगी और कंसेंसस से ऑर्डर पास होगा तो पार्टीज को सेटिस्फेक्शन भी मिलेगा नेचुरली एंड बट देयर विल बी नो अपील अगेंस्ट सच सेटलमेंट। मतलब इसके खिलाफ कोई अपील का प्रावधान नहीं होगा। इसी कंटिन्यूएशन में जो कुछ अमेंडमेंट किए गए हैं नए लेजिस्लेशन में वो है कि इन्हांसमेंट ऑफ द पेकुनियरी जुरिस्डिक्शन ऑफ द कमीशंस। हमारा जो डिस्ट्रिक्ट कमीशन है इसके आर्थिक क्षेत्राधिकार को बढ़ा करके 1 करोड़ रुपए तक के मामले की सुनवाई करने का अधिकार दे दिया गया है। स्टेट कमीशंस को 1 करोड़ से लेकर के अप टू 10 करोड़ रुपीज तक के मामलों की सुनवाई का अधिकार दिया गया है और अगर 10 करोड़ रुपीज के ऊपर का कोई मामला है तो उसमें नेशनल कमीशन में सुनवाई का अधिकार दिया गया है। तो इस तरीके से जो इनका आर्थिक क्षेत्राधिकार बढ़ा दिया गया, सबसे बड़ा बेनिफिट होगा कि नेशनल कमीशन और स्टेट कमीशन पर वर्कलोड कम हो जाएगा। अब ज्यादा से ज्यादा मूल्य के मामले जो है वो डिस्ट्रिक्ट कमीशन के लेवल पर निपटारा किया जा सकता है और इससे स्टेट कमीशन और नेशनल कमीशन का वर्कलोड कम हो जाएगा। जहां तक टेरिटोरियल जुरिस्डिक्शन की बात है, एक बहुत अच्छा चेंज किया गया है इस इनएक्टमेंट में, नहीं था, और वो है कि दिस विल ईज द बर्डन ऑफ कंज्यूमर्स। पहले कंज्यूमर को या तो जहां प्रतिपक्षी रहता है या जहां पर कॉज ऑफ एक्शन अराइज होता है वहां पर कंप्लेंट फाइल करने की सुविधा थी, लेकिन नए इनएक्टमेंट में अब कंप्लेनेंट को अपने प्लेस ऑफ रेजिडेंस या अपने प्लेस ऑफ वर्क में भी कंप्लेंट फाइल करने की सुविधा दे दी गई है। अब इसके लिए अपने कंप्लेंट के लिए उसको दूसरे जगह पर भटकना नहीं पड़ेगा। इसी प्रकार से अपील से रिलेटेड जो मामले हैं उनको थोड़ा स्ट्रिक्ट बना दिया गया है और स्टेट कमीशन के ऑर्डर के अगेंस्ट नेशनल कमीशन में अपील तभी की जा सकती है जबकि उस मामले में कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ इन्वॉल्व हो। सब्सटेंशियल क्वेश्चन ऑफ लॉ अगर नहीं है तो सामान्यतः अपील की अनुमति नहीं होगी। और अगर कोई व्यक्ति नेशनल कमीशन के ऑर्डर के अगेंस्ट में सुप्रीम कोर्ट में अपील करना चाहता है तो वह तभी अपील कर सकता है जबकि वह मामला नेशनल कमीशन में ही इनिशियली फाइल हुआ हो, तभी वो अपील कर सकता है और सुप्रीम कोर्ट में जा सकता है। तो इस तरीके से अपील से रिलेटेड जो प्रावधान थे उनको थोड़ा सख्त बना दिया गया है और इसका परिणाम ये होगा कि मामलों का टाइमली डिस्पोजल हो जाएगा और द कमीशन विल प्रोवाइड द क्विक रेमेडी टू द कंसर्न पर्सन्स। और एक जो सबसे बड़ा परिवर्तन लाया गया है इस अधिनियम के द्वारा वह है with regard to authenticity and accountability of the advertisements। विज्ञापन को लेकर के जनता बहुत परेशान होती है और विज्ञापन के द्वारा प्रेरित भी होकर के लोग बहुत ही परेशान होते हैं। तो उन सारी चीजों को, विज्ञापन से संबंधित समस्याओं को रोकने के लिए, जैसा मैंने अभी बताया था कि सेंट्रल अथॉरिटी को पावर दिया गया है कि वो ये सुनिश्चित करे कि कोई भी झूठा या भ्रमपूर्ण विज्ञापन न होने पाए जो कि इस अधिनियम के प्रावधानों के उल्लंघन में हो। ऐसा कोई गलत या मिथ्या विज्ञापन न होने पाए, और अगर ऐसा कोई विज्ञापन किया जाता है तो सेंट्रल अथॉरिटी उसको डिसकंटिन्यू करने के लिए या उसको मॉडिफाई करने के लिए आदेश दे सकता है, या अगर उचित समझता है तो पेनाल्टी भी इम्पोज कर सकता है। और एक बार पेनाल्टी इम्पोज करने के बाद भी अगर बार बार विज्ञापन का उल्लंघन किया जाता है विज्ञापन के द्वारा, तो पेनाल्टी और सख्त हो जाएगी और उसकी राशि बढ़ा दी जाएगी। साथ ही साथ यहाँ पर एक और महत्वपूर्ण बात है कि जो सेलिब्रिटीज ब्रांड एम्बेसडर के रूप में काम करते हैं विज्ञापन में, उनके लिए भी प्रावधान बना दिया गया है कि वो भी बहुत ही सावधानी के साथ और विज्ञापन की सत्यता परखने के बाद ही किसी भी कमोडिटी का विज्ञापन करेंगे, क्योंकि अगर वो ऐसा नहीं करते हैं तो उनके लिए भी पेनल प्रोविजन कर दिया गया है, उनको पेनलाइज किया जा सकता है। तो इन सारी चीजों के अतिरिक्त और भी कई छोटे छोटे बदलाव किए गए हैं। जैसे गुड्स की जो डिफिनीशन थी उसको और मॉडिफाई किया गया है और गुड्स के डिफिनीशन में फूड को भी शामिल कर दिया गया है। फूड का जो डेफिनेशन फूड सेफ्टी एंड स्टैंडर्ड एक्ट 2006 में दिया गया था, उस डिफिनीशन को यहाँ इनकॉर्पोरेट किया गया है। अब इसका लाभ ये होगा कि जो फूड इंडस्ट्री, जो फूड डिलीवरी प्लेटफॉर्म्स डेवलप कर रहे हैं इस समय, दे विल आल्सो कम इन द परव्यू ऑफ दिस एक्ट। तो उनके खिलाफ भी कंज्यूमर जा करके फोरम में रेमेडी ले सकता है। दूसरा जो बदलाव किया गया है वो द डेफिनेशन ऑफ कंज्यूमर हैज बीन ब्रॉडेंड and now it covers the transactions through all modes: offline mode, online mode, teleshopping, direct selling or multi-level marketing। मतलब every type of marketing has been included under the definition of consumers, and the persons who are marketing through any of these mediums, they will be treated as the consumer under the definition and they can avail the remedy under the consumer protection law. Thirdly, this new enactment provides swift and less time consuming process by enabling electronic filing of the complaint as well as वीडियो कॉन्फ्रेंसिंग। ये जो प्रावधान कर दिया गया है कि वीडियो कॉन्फ्रेंसिंग के द्वारा मामले की सुनवाई हो जाएगी या ई फाइलिंग ऑफ द कंप्लेंट्स हो सकता है, इलेक्ट्रॉनिक फाइलिंग है, और पार्टिकुलरली जो कोरोना पेंडेमिक के दौरान जो चेंजेस आए हैं उसका भी लाभ मिलेगा, और कोरोना काल में ये लेजिस्लेशन भी बना था। तो कहने का मतलब ये है कि इससे और ही शीघ्रता से मामले का निपटारा किया जा सकता है, और ये सारे परिवर्तन आए हैं। तो अभी तक तो मैंने सारी सकारात्मक बातें की हैं, इसमें कुछ प्रैक्टिकल प्रॉब्लम आ सकती है। देयर आर सो मेनी लैकुना, बट वी शुड नॉट थिंक निगेटिवली, वी शुड बी पॉजिटिव। और लास्टली आई वुड लाइक टू से that this is not an old wine in new bottle, but this is new wine in new bottle.
Thank you so much, Professor Upadhyay. You have, after listening to Professor Upadhyay, I hope हम लोगों के मन में जितनी भी बहुत सारी चीजें थी कि as a consumer हमें we will get justice or not and how we will protect ourselves, वो सारी चीजें हमारे मन से अब धीरे-धीरे solve हो गई होंगी. And we have with us another speaker, Mrs. Deepa Sharma, who is a member of the National Consumer Commission, and she will be talking about the practical aspects of the changing dimensions of consumer protection in India. Ma'am must be encountering number of cases. Consumer के जो हमारे cases होते हैं वो उनके forum में जाते होंगे, और there are various aspects of the cases, different type of cases. So she will be speaking, she will be throwing light on that. Before I ask our next speaker to start this session, I'll just give a brief introduction about her. Mrs. Deepa Sharma, she graduated from the Faculty of Law, Delhi University in 1978. She pursued law after completing her degree in Bachelor of Science. After having practiced law for nearly 2 years, she qualified the DJ's examination and joined the Delhi judiciary as civil judge in September 1980. In a long and successful tenure at the Delhi Judicial and Higher Judicial Service, she has earned many laurels. Her most recent accomplishment is the setting up of family courts across different districts in Delhi. She was the first principal judge of the family courts and is responsible for creating the empathic culture and the streamlined process, which is the pride of these courts. She has embraced new and alternate practices in law, like mediation, and is a certified practitioner and trainer of the same. She established the Mediation Center at District Courts Dwarka. She has also traveled extensively to impart training in mediation as an alternate method to dispute resolution to various groups of lawyers and judges across the country. Before being elevated to the Delhi High Court, she headed the Dwarka Court as the district and session judge. She has gained a wide experience due to the various positions she held during her tenure as a district court judge. Some of these positions are Judge MACT, NDPS, Judge CBI, Sessions Judge for cases under ITP Act and others, Judge Labour Court, ACMM, Senior Civil Judge, RCT, etc. She has pursued academic interest and taken lectures on various aspects of law at Delhi Judicial Academy and National Law University. Her other interest includes poetry, music, and gardening. And she was elevated to the bench of High Court of Delhi as an additional judge on 17th April 2013. And right now she is a member of the National Consumer Commission. Ma'am, please. Ma'am, you're not audible.
Thank you. Honorable Vice Chancellor, Professor Nagesha Rao. Am I audible now? Yes, thank you. Pro Vice Chancellor, Professor Sumitra Kukreti, respected Professor C.P. Upadhyay, Dr. Suneet K. Srivastava, Director Soul, and dear audiences, on screen and off the screen. Namaskar. I really feel honored to be part of this event organized by the IGNOU. IGNOU is a world-class institution running a number of distance learning programs of higher education. This has benefited crores of students in attaining higher knowledge in different fields. I congratulate all those who are connected with this world-class institution for their hard work and dedication. I really feel privileged and honored to address such a wide range audience of IGNOU. Thank you. Professor Upadhyay has spoken extensively on the new dimensions about the new law and the consumer movement in our country. So I need not repeat all this during my this lecture. I would focus on the practical aspects of the consumer protection in India and the difficulties we feel, and also the pragmatic approaches we have, the courts have been, and the commissions are taking while giving relief to the consumers, despite many of the things not being incorporated in the old act. So in the older times, or 50, 60 years back, when local was vocal, consumers used to buy goods from the nearby shops, and the redemption of their difficulties were very, very easy, because the person from whom they used to buy goods used to replace it or change it, because they also all knew, known to each other. But now, when the scenario is changing, we have e-portal, web portal, and e-commerce sites where the consumer is not even aware of the face of the service provider or the manufacturers. We buy the goods on the basis of details provided on the site. So we, as a commission, a member of the commission, always, even before this new act had come into operation, were aware of these difficulties of the consumers which they were facing, and for which there was no redressal mechanism under the old act. But still, by taking a pragmatic approach, we used to redeem and redress their difficulties. Now, the safeguarding the interests of consumer was always a paramount concern of the legislature, and this is evident from the various regulations which require the manufacturers to have certification of Standard Institute ISI on their products. FSSAI, Food Safety and Standard Authority of India, deals with the regulation to control quality standards in the food products, etc. Agriculture products are required to carry the seal of IGNOU. The producers and the manufacturers are also required to follow the standards provided under the Standards of Weights and Measurement Act. Availing the service in buying the goods is a form of a contract, and the Contract Act provides the duties and the remedies arising out of a contract. Several other legislatures like Drug Control Act, the Essential Commodities Act, and MRTP, etc., were addressing the difficulties of the consumer before the passing of the Consumer Protection Act 1986. The expression of consumer was not known before this act came into force, and for the first time, the general public who buys the goods has been categorized as a consumer, and their rights are recognized and protected under the Consumer Protection Act 1986. In 36 years since this act was brought to the statute book, the law on the subject is continuously developing, fulfilling the needs of society and the consumers. It is one of the most progressive and comprehensive piece of legislation taking care of the welfare of the consumers. Being a social welfare enactment and having its own challenges with the fast-changing needs of the society, the commissions and the Honorable Supreme Court, in exercise of its appellate jurisdiction, have always been adopting the pragmatic and practical approach to remove the difficulties of the consumers. The three-tier commission, District Forum, State Commission, National Commission, all three of us have original jurisdiction, have been set up under the Act, providing remedies to the consumer. The procedure which we follow is very simple. We follow the procedure of summary trial, where it's not a litigation like a civil suit where lengthy evidences are being led and extensive arguments are being done, and the entire burden is on the petitioner to prove its case. Here, on the basis, it's a summary trial in the sense that all the basis of documents and admission and denials by the parties, we decide the evidences are led on affidavits, and also the liberty is given to the parties to call the witnesses for cross-examination if need arises, and that too with the permission of the commission. Generally, this cross-examination sort of thing is done by exchanging the interrogatories, like enumerating the questions which need to be answered by the opposite party, and the process of cross-examination is minimized. I can say it's nil. It is not known. We do not generally permit any witness to be called and cross-examined. This is an act which provides an alternative, efficacious, simple and inexpensive and speedy remedy. This remedy is not allowed to be curtailed on the ground that a complex issue of law and fact is involved, which requires scrutiny of documents and cross-examination. We refrain from directing the consumers to approach the civil court on these grounds, and the forums under the Consumer Protection Act are fully empowered to discharge justice to the consumers by adopting summary procedure. It has been so held by the three-judge bench of the Honorable Supreme Court in Dr. J.J. Merchant and others versus Srinath 2002 6 SCC 3635, where the Honorable Court has said that the Commission is fully empowered to deal with the matter, even if there are number of documents or the issue involved is complex. Whenever a complaint, appeal, revision petition is filed, it undergoes a scrutiny. The concerned official of the registry scrutinizes to see that it is free from any formal defects like jurisdiction, limitation, and contains requisite annexures and affidavits, memo of parties, and wakalatnama and the documents which is required to file along with the complaint as per the Act itself. Thereafter, if no defect is found or removed, it is placed before the appropriate bench for its admission. During the COVID time, the Commission allowed the consumer to file cases online using web portal e-Dakhil. We are still following the same e-portal for e-filing, and it can be filed, the complaint can be filed online from anywhere at the comfort of their own, and also pay complaint fee and monitor the status of the case online. E-Dakhil portal had been launched by NCDRC, by us, on 7 September 2020, and thereafter the facility was launched in 23 states or union territories for respective state commission and district commissions. Our endeavor is to provide this facility to all the us around the country. The expression consumer is given definition for the first time under the Consumer Protection Act and is defined as a purchaser of goods for consideration and or the person who hires or avails any services excepting those which are done for commercial purposes. So if any person buys a good or avail the services for his business for commercial purposes, then he is not a consumer under the Consumer Act, and he has to avail his remedies in the before another fora like civil courts, etc. The Honorable Supreme Court in the case of Lakshmi Engineering Works versus PSG Industrial Institute 1995 3 SCC 13 clarifies the distinction between consumer who purchase the goods or avail services for his own use and the one who does it for business and commercial purposes. Even the farmers who are sold defect seeds by the government company or otherwise are declared consumers and compensated for such deficiency under this Act by the Honorable Supreme Court in the case of National Seeds Corporation Limited versus M.M. Madhusudan Reddy and others, 2012, 2 SCC 506. Generally, we feel that a person has a family and he has two children, so he generally he wants to buy houses, one for himself, one each for his children. So he buys, suppose, 3 houses, and the builders from whom he buys the houses take this plea that because he has bought 3 houses, so he is not a consumer, he has not bought it for his own purposes, but his intention is, he is an investor, and his intention is, he bought it with the intention to sell it in future in the public and earn profit, in the market and earn profit. But the Honorable Supreme Court has clearly held that in the case of Kavita Ahuja versus Shipra Estate 2015 SCC online, NCDRC 2747, this commission, not the Supreme Court, has come to the rescue of such bias, and we have clearly held that if the house is bought for the purpose of his living and for the purpose of living for his two children, then he is not a he is not out, he falls in the category of consumers, and it is not bought for commercial purposes, and we reject the arguments of the builder that it is bought that he is not a consumer, and the burden is entirely shifted upon is put upon the builder to prove that that the person is dealing with in the business of buying and selling the houses, and that it is, since it is his business, so he has intended to buy these houses also for the said purpose. But if the investment is done for the welfare of their children, his family, then we have clearly held that a number of pronouncements other than Kavita Ahuja, that he is a consumer within the meaning of Consumer Protection Act, and have granted relief to him. Also, if the consumers, various consumers, like in a multi-storied building, if there is a delay in giving the possession, all the consumers, all those who have booked their flats in that multi-storied, are the consumers who have similar interests and who claim similar reliefs. So, this act itself allows, under 35(3)(c), the old act, new act also allows the same. So all those consumers can form an association instead of coming individually, can voluntarily form an association and file one complaint for redressal of their problems, the difficult, a joint complaint. However, if the caution is that if any act mandates that an association of such flat buyers is to be formulated, is to be made, then such association cannot file a complaint on behalf of the consumers. They are not consumers, not treated as consumers. It has been so held by Honorable Supreme Court in Shobha Hibiscus Condominium versus Managing Director of Shobha Developers, appeal number 1118 of 2016, which was decided on 14th February 2020. Also, this commission, the builders, in the case of buildings, always come up with one excuse or the other regarding the delay in handing over of the possession. And they want that even if there is a delay, such a delay, huge delay, or a delay by 1 year or 2 years, if during the pendency of the trial before us, they are ready to hand over the possession, then they ask the commissions to ask the allottees to take the possession of the house. But this commission has held in several pronouncements that a builder, if has not been able to deliver the possession within the stipulated period, and after a reasonable delay, even if he is not in a position to deliver the possession, he cannot force the allottee to take the possession, and he is bound to refund the money along with appropriate interest rate and also damages and compensation. And this viewpoint was confirmed by the Honorable Supreme Court in the case of Pioneer Urban Land and Infrastructure Limited versus Govindan Raghavan and Civil Appeal number 12238 of 2018. Also, now in the new act, it has been recognized that a wrong advertisement is punishable, right? They have to pay the penalty for advertising anything wrongly. But this commission but the Honorable Supreme Court has, even before this new act had come into force, had dealt with the difficulties of the consumers, where in a brochure certain promises are made, but those promises are not kept. And the Honorable Supreme Court has said that the builder is bound to provide all the facilities which he had promised in the brochure, even though those facilities are not part of their agreement, builder-buyer agreement. It has been so held by the Honorable Supreme Court in case of Wing Commander Arifur Rahman and others versus DLF Southern Homes Private Limited. Stop. Still, we feel everybody is aware that the directors of Unitech is already in jail, and the Supreme Court is coming heavily for their conduct and is keeping them in jail since 2017, since they have diverted the home buyers' money to their other projects, and they have been directed by the Supreme Court to refund that money, to deposit that money which they had collected from the home buyers with the registry, so that it can be returned to the buyers, and keeping them in jail since 2017, since they are not able to refund that money. Also, in the case of Jayaprakash Infrastructure Limited, who are pioneer in the construction field, when it is found that they are also diverted and siphoned off the money of the home buyers in other projects, the Honorable Supreme Court had taken care of that project and had and under a plan, they have appointed the NBCC to complete that project and hand over the possession to the home buyers. And this clearly shows that the